morning, good afternoon, and good evening to one of our present here and from to all the people from around the world. I'm Svetan JS, part of the Managing Committee of KFCRI. I welcome you all to this webinar. This is actually part 2 of the webinar, which has already happened yesterday. We welcome Mr.Yilli Dautaj and our moderator here for the session, Ms.Sameena Syed, and our project advisor, Mr.V.Inbavijayan. For those who were not able to attend yesterday's part of this webinar, you can do so in our YouTube page, which was uploaded last night. And if you had any unanswered questions of yesterday's webinar, you can, of course, post it to kfcri.adr@gmail.com. For those who are here again for new, a brief introduction of KFCRI as an institution. KFCRI is an arbitration center and it provides its services as an ADR center in all the fields of ADR, such as arbitration, mediation, conciliation, negotiation, and even as a tribunal secretary. For all of this, we have our rules and clauses which can be incorporated in various contracts. And if there's any disputes arising out of such contracts, it would be adjudicated by the institution. Apart from this, KFCRI functions as an accreditation body as well, where we provide training and have assessments for various practitioners in the field and provide accreditations again in all the fields of ADR, such as arbitration, mediation, conciliation, and also we accredit individuals as tribunal secretaries. Before we move on to the webinar, a bit of housekeeping. Anyone who has any questions during the course of the webinar is welcome to put forth their questions in the Q&A box, which you can find below. And the last 15 minutes of this webinar is reserved for answering those questions. Thank you so much. Over to Mr. V.Inbavijayan.
Thank you, Svetan. It is the back-to-back event what's happening today, and we welcome Mr. Yilli Dautaj to continue on his promotional activities about the investor-state arbitration, which is very much required, whether it is going to be young lawyers or practitioners quite serious in the arbitration field. The very understanding of this particular sector-specific arbitration is the need of the hour. And not delaying further, I'll just hand over to Sameena.
Thank you, Mr. Inbavijayan. Thank you, Mr. Suvair, for giving me a wonderful opportunity in moderating this session as well. And I deem it an extreme privilege and honor to be talking to Mr. Dautaj even today. Mr. Dautaj, thank you so much for tuning in today, and it's an absolute pleasure to have you on board. So we were discussing about investment treaty arbitration generally along with its overview yesterday. And today I'm very excited to talk about this specific topic with regarding to prevention and mitigation of investment treaty disputes, especially when it's the current and the most topical talk of the hour and most important procedure that must be looked forward into as we move towards a greater economy or when we're going to sign a lot more BITs. So Mr. Dautaj, my first question in today's session is that even though prevention and mitigation has been talk of the town and it's been discussed by the UN way and again, it is not clear what is the exact sense of prevention and mitigation of disputes. So could you please talk to us about what is prevention and mitigation of investment disputes?
Okay, so first and foremost, again, today as yesterday, thank you very much. It is indeed my honor and my privilege and my pleasure to be here virtually with an esteemed arbitrator like Mr.Inbavijayan, and also to be with the entire team of KFCRI. And I will say, Sameena, that it is my pleasure to be meeting you, such an energetic and highly skilled young student. So the pleasure is all mine. To your question, and I will put it easy or simple in the first question, because I know that we will continue with a series of questions and qualify. But I would say that prevention and mitigation is, very simply put, any measure that reduces the occurrence of ISDS. And then it is up for your imagination or the imagination of various bodies of exactly how to achieve that aim. So this is, the aim is, or the consequence of taking measures that reduce the occurrence of ISDS, Investor Dispute Settlement, is to improve the business environment and resolve problems before they turn or crystallize into disputes. And as I will say throughout this hour, I mean, this is by no means something new. I mean, trying to prevent and reduce disputes has been the talk of the hour for centuries. And now it's more topical, but I feel that it is an underestimation of many developing states to say that we need prevention and we need mitigation of disputes. Because, of course, everyone that has been involved in dispute resolution understands that the best thing you can do is to prevent the dispute. And as an example, if you look at the Energy Charter Treaty, they do not only have a treaty, they have other services too, such as the Energy Investment Risk Assessment, in short, EIRA. This is, and I will read straight from their webpage, a publication of the Energy Charter Secretariat that evaluates specific risks affecting energy investment that can be mitigated through adjustments to policy, legal, and regulatory framework. So it aims to identify policy gaps, provide learning opportunity, and stimulate reforms which can make the investment climate of countries more robust and reduce the risk of investor-state disputes. This is a typical example of a prevention mechanism or mitigation mechanism of potential disputes. This has been a part of the Energy Charter's services for quite a while. Another good idea, I would say, is the Advisory Center, the UN Advisory Center on ISDS. And this is especially good because this is backed up by expert law firms and experts from around the globe. And this group could potentially address some of the concerns that has been identified by, for example, the UN Working Group, but also other NGOs, international organizations, states, scholars, and so on and so forth.
Thank you, Mr. Dautaj. Mr. Dautaj, we do understand that conflict is inevitable, but combat is optional. So can you tell us why prevention and mitigation is necessary in the realms of investor-state disputes?
This is, again, it has one very straightforward answer, and then it can be discussed from the lens of nuance, scope, and degree for hours. And the first quick answer is, of course, it is necessary, and most people understand that, let alone experts, lawyers, professors, politicians. So this is a bit of a fallacy, I would say, that international organizations, some states, NGOs throw up. In other words, dispute resolution is the last venue for redress of grievances, of course. So the hope with an investment is not to be dragged into lengthy, costly disputes. So the purpose of an investment is to make money. And while you make money, you improve the quality of your products and your services. So can awareness and other measures help states to improve their management of incoming FDI, in other words, foreign direct investment? Yes, of course. Yes, of course. So the question is rather, how will it actually be implemented? So I don't think a single honest soul would be against the idea of prevention and mitigation at the pre-establishment phase. What would be more problematic is the post-measure prevention and mitigation. In other words, where things start to go, as we express it, south. In other words, things turn out to not be as good as they were intended. So investment treaty arbitration was meant to be a substitute for diplomatic protection, and it was meant to level the playing field between the investor and the state. I do not believe, personally, that investors would be too keen to have their legal disputes subject, once again, of a political debate. And that is the exact scope that investment treaty arbitration was aimed to and have successfully, I would say, filled.
Thank you, Mr. Dautaj. My next question is regarding implementation. How can prevention and mitigation be implemented both at the national level as well as in the international level?
Okay, so that's a very good question. And I would say to answer this question, let's look at the UN General Assembly document on possible reform of ISDS and dispute prevention and mitigation as an alternative dispute resolution feature, let's call it. And this document divides prevention and mitigation into three brackets: national, treaty level, and international. And the national level includes, for example, identifying a lead agency, in other words, an agency that establishes communication, mapping of information and making it available, such services as you can retain from, for example, Kluwer Arbitration or UNCTAD, the policy hub. It includes measures such as raising awareness among governmental officials and various different trainings, such as KFCRI is providing, right? Training to becoming arbitrators and practitioners in the field. Early settlement discussions is another such national measure to mitigate and prevent disputes, etc. The treaty and international level, on the other hand, can include, for example, state-to-state cooperation or capacity building, whatever that means. It's a broad concept. People like to say capacity building, but what it actually means is more cumbersome to discern.
Thank you, Mr. Dautaj. Mr. Dautaj, small changes or small steps lead to greater success. According to you, what are the steps or precautions that the parties must take, in order to prevent or mitigate an investment dispute?
Okay, so this is really good. And the parties, in other words, being the investor and the host state. So in that light, I will give a few different suggestions and alternatives, but I mean, the list can go on and it's scope for imagination. So we have hundreds and thousands of participants in this webinar. So it's up for your imagination to determine what is the best way to prevent and mitigate potential disputes. So I'll give you a few suggestions. From a state perspective, you can, as India has done, engage in restructuring and managing treaties. For example, what you can do is you can outline the scope of a right to regulate as a state, and therefore combat some of these claims under investment treaties for a breach of fair and equitable treatment or indirect expropriations. You can, for example, amend institutional rules or treaties to remove frivolous claims, such as the exit reform suggestion that allows for an objection of a claim that is manifestly without merit. Then you have the investor. So what can an investor do? An investor can use its contractual power to strengthen its position. But let me qualify this. This is more likely if you're a multinational corporation and has a strong bargaining power, as opposed to if you're a small and medium enterprise, which is actually the greatest beneficiaries to the investment treaty arbitration system and international investment law as such. So a investor that actually has bargaining power can, for example, include freezing clauses, and to what extent those clauses will be redressing your grievances when a dispute arises is yet another academic and practical debate that carries different answers. Can include a renegotiation clause. You can include international law in the governing law, in other words, the applicable law in your contract. You can include, and if you have a very strong bargaining power, a waiver of sovereign immunity also from the execution of a potential award. So that's a few examples. And then you're free to visit the UN documents, you're free to read more about it, and also you're free to think. That's why we're here. And that's what you're all aiming to do, to be thinking about possible solutions and not just hearing me repeat what has already been said.
Thank you, Mr. Dautaj. Recently, the UN Working Committee suggested the importance of having an ombudsperson or an entity along with the Joint Commission for better administration of treaty obligations. Can you please talk about the same, and how will the suggested methods work if it's brought into effect?
Yeah, so ombudsperson, quite funny, is actually a Swedish word. So an ombudsperson is an institution that is mandated to receive complaints and try to resolve the so-called grievances at an early stage. We cannot go into their exact mandate, as it depends on the authority that is given to the ombudsperson. It could include, for example, making policy recommendations. It could include mediating disputes. A joint committee is typically I say, a composition of government officials from respective country in a bilateral investment treaty or in a multilateral investment treaty. The joint committee can meet to, for example, discuss treaty-related matters, such as implementation of the treaty, attracting, promoting, and retaining foreign direct investment. They can discuss manners in which or how to resolve disputes, etc. My answer to a good idea is that it remains an ideal until put to test. So what I'm asking you all, or what I'm asking you to think about rather, is what if the ombudsperson takes measures that interferes with an investment? What if the joint committee takes measures that constitutes, or at least leads to a claim of a denial of justice, if possible? So Professor Dr. Kajubir, whom is one of the trusted advisors to KFCRI, has an excellent expression in his book on investment treaty arbitration. Namely, as he puts it, the proof is in the pudding. So that would be a short answer with some following questions for you to elaborate on your own.
Thank you, Mr. Dautaj. Mr. Dautaj, my next question is pertaining to abuse of process. Abuse of process is one major concern when it is looked into the realm of investment treaty disputes. So, especially when it comes to bringing forth the same claim against the same state, but under two bilateral investment treaty agreements, will this be curtailed if enforcement of prevention and mitigation is brought into effect?
So in theory, it will at least help alleviate some of the abuse of process. In practice, as I said, what if the new bodies act in a manner that is considered to interfere with an investment? Remember that institutions are a composition of people. If you train the composition of people right, you improve matters, of course. But how much time and resources do we have to train and equip the entire world to follow one set of mental representation of how to organize, implement, coordinate, and effectively manage FDI policies? So this is a scenario of mission impossible in one way. And we may need to call in Tom Cruise to handle things. But the ultimate question is, how much resources do you have to put in place to fully prevent and mitigate disputes from occurring? And will it even be possible? To some extent, yes. And to some extent, no. So the bottom line is actually pretty simple. Prevention is always a key to minimize bad outcomes, always. No one in the right mind will rebut such a proposition. then the question is, will it radically reduce investment claims? Who knows? Who knows? Is it worth trying? Yes, indeed. Yes, indeed. At any cost? Probably not. Probably not. At some cost, I would say yes, indeed. Yes, indeed. And that has been some good developments with, for example, the UN Advisory Board.
Thank you, Mr. Dautaj. Mr. Dautaj, in the view of prevention and mitigation of treaty disputes, will the states have to work or rework on their model laws or model BITs?
Okay, so I will break this down in 3 sub-answers. Do you want me to talk about the Brazil-India Investment Cooperation Facilitation Treaty now, or do you want me to
we can have it in a different setting, because we'll first give an overview about how the model laws will work, and then your views about the India-Brazil treaty.
Perfect. Okay. So I would say this, Sameena, states will always have to work on new model bits in order to reflect current realities and subsequent changes. If I agree personally or disagree with a particular development is one thing. And I can disseminate my thoughts or my opinions through scholarly research and through publications or to participate in webinars. But change through reform and sometimes even transformation is inevitable. So I have a favorite expression that I always think about, because I have a particular fond interest in legal theory and philosophy, and that is the expression, changing it rests. So yes, some change is inevitable. Some reforms are inevitable and good. And to some extent, even transformation is called for. But then you also have radical reforms and radical transformations, which I do not personally agree with, such as the EU's proposal on a total transformation of the investment treaty arbitration regime. And I have a paper coming up in Northwestern Journal of International Law and Business that will reflect my views on that.
Thank you, Mr. Dautaj. As you rightly pointed out, India recently signed an investment treaty with Brazil, which is known as the India-Brazil Investment Cooperation and Facilitation Treaty. Could you please break down this treaty for our audience? And can you tell us, is this the pathway to the new beginning?
Okay, so I start with the last one there. I think it is definitely a pathway to a new beginning. Yes, is the answer to that. But is it the right pathway and a welcome new beginning? That's a separate question of which I am not so sure. Some things are truly good, such as including investor obligations and the widening of applicable law. Those are good developments. So to take the India-Brazil International Investment Agreement as an example, my views can be summarized as follows. It is a good idea, but this is another favorite expression of mine. If you stand for everything, simultaneously you stand for nothing. Also, it must be brought to the attention of the audience that Brazil is very anti-ISDS. And it seems they are pretty anti-international investment law too. So nowadays we see in South America, for example, some countries, a revival of, or better put, a re-emerging of the Calvo doctrine. And as you know, really love India, I don't see that this is the path I want to see for India. India had an economic boom, not despite of the new economic policies adopted in the 90s, but because of such fundamental aligning with the US and Europe. India, according to me, has the potential to be an economic leader in a few years' time and remain so for decades to come. India has great education, culture, expertise, geopolitical strength, faith-based core, and many more qualities. India, I think, should take steps to enforce the global rule of law and entrench itself as a leader also in transnational commerce, trade, and investment. So I have this treaty in front of me. I will go over a few parts quickly just to underscore the new additions in this treaty, just to bring them to your attention. So if you look already in article number 2, you can see that in this treaty, there is a qualification of what constitutes an investment, where they include for greater certainty, investment does not include, and they give a few examples. That's a pretty restrictive approach to what qualifies as an investment. Then in part 2, you have treatment of investments. In Article 6, it talks about direct expropriation, which generally speaking has not been too much of a problem. And that undercuts the idea of indirect expropriation, which is more of a problem. So if you remove fair and equitable treatment and indirect expropriation, you're really undercutting substantial protection from investors. A good development in this treaty is a particular focus on transparency in Article 8. There is in Article 10, investment measure and combating corruption and illegality, which is generally speaking a good thing. But then in the arbitration clause, it removes the mandate of a tribunal to handle such legal issues. That has been a very topical debate, whether a tribunal has the mandate, in other words, the jurisdiction and competence to try matters of corruption. So one good and one slightly negative on that one. Then you have something that is really good. In part 3 of this treaty, you have investor obligations and responsibilities, which includes compliance with laws, corporate social responsibility, which we understand a corporate social responsibility is a soft law. So, and perhaps not even that. So it's a code of conduct. So what happens here? Is this to be elevated into a legal compliance mechanism? Or is it a best practice, which is good for investors to abide by, but not necessarily mandated? And if it is mandated, to what extent? So, I mean, it becomes problematic. Then in Article 13, you have, as we discussed earlier, a joint committee for the administration of the treaty. But not only that. So in Article 14, you also have a national focal point or an ombudsman. So you have a joint committee and an ombudsman, which is, I mean, as I said, you stand for everything. Then you have, on top of that, in Article 18, a dispute prevention procedure, which is good in and of itself, but going through the hurdle of a joint committee, an ombudsperson, a dispute prevention procedure, only then to, in Article 19, have disputes between the parties referred to arbitration, which has significantly narrowed jurisdiction and competence of the tribunal, which includes in Article 19.2, and I quote, "The purpose of the arbitration is to decide on interpretation of this treaty or the observance by a party of the terms of this treaty. For greater certainty, the arbitral tribunal shall not award compensation." This is a completely new type of arbitration. Limited mandate, limited jurisdiction, limited competence, limited substantive matters to be heard, and not even a mandate to order compensation. And it goes on. Article 21 talks about prudential measures. Article 22 talks about provisions on investment and environment, labor affairs and health, which is good in and of itself. Article 23 outlines general exceptions. Article 24 outlines security exceptions. So you see, this treaty or this international investment agreement is very different I would say, radically different from traditional bilateral investment treaties. Is it good? To some extent, yes. I would say some parts are really good. Some parts are the opposite. And is not really my cup of tea. But as in any other aspect of legal debate, what is my cup of tea doesn't really matter. It is what is the majority's cup of tea, having assessed the implications and positive and negative outcomes of a particular policy orientation or measure. So I am of the view that investment treaty arbitration is a policy undertaking which promotes foreign direct investments by providing for an artificial element of trust to investors so that they actually do invest, with hedging the risks that worst outcome, they can at least bring a sensible case against the state and recover its financial losses. So that's my opinion, and that has been put forth in various academic papers and also here with you now. But if I'm right or wrong, that's a perception. If you agree, fine. If you disagree, even better.
Thank you, Mr. Dautaj. It was indeed a detail and breakdown of every article that's present in the treaty. Mr. Dautaj, my next question is, do you think lack of knowledge among the grassroots level people who are working for these foreign investors also is a prime cause for investment dispute? And how can this be mitigated in the realms of prevention?
So I'm not sure I follow the question, but yes, so everyone that is involved in the investment, be it local authorities, be it government officials, or be it leading positions of the company, in other words, the investor that is managing the investment, can have a positive and adversely negative effect on what is going on the ground. Can training of these people help remedy ISDS disputes, in other words, prevent them from occurring? Most definitely. Most definitely. As with everything else. I mean, if you put up red lights, yellow lights, green lights on the road, will that help prevent and mitigate traffic accidents? Most likely, yes. If we have a rule imposed, a legal rule that says that every third family can drive on Monday, every third family can drive on Tuesday, every third family can drive on Wednesday, will that help prevent and mitigate disputes, traffic accidents? Yes. So the question is not, can we prevent and mitigate investor-state dispute settlement procedures from occurring? In other words, measures being taken that defects or adversely affects investments. Yes, of course we can. And the more money we invest in that, the more likely it is that we actually prevent and mitigate disputes from occurring. But how much are we willing, or how much can we invest? And then even if we do, so suppose that we set up, as I said, ombudsperson institutions and joint committees. These are still institutions that are created by the composition of people. It's no artificial intelligence there. Even that would be perhaps even worse. But so these are people, and people will commit mistakes. So if you go by the presumption that you put together an institution and that institution is perfect, then yes, I mean, it will be very successful. But in reality, that doesn't happen. So institutions are not perfect because people are not perfect, whether it is the investor or whether it is the state. We're not perfect. We're not free from fault. So that is exactly the risk we're taking in investment. It is also the risk that we're taking by attracting foreign direct investments. And it is in that risk that we offer a dispute resolution system that can help address the grievances.
Thank you, Mr. Dautaj. My next question is pertaining to the cooling period. So what is cooling period and why is it considered vital when it comes to a dispute resolution mechanism?
Okay, so when a dispute has crystallized, in other words, you know that you have a dispute. If you have a cooling off period, this means that the investor is required to hold off, back off for a specified period. This period can be 8 months, this period can be 1 year, 2 years. It depends on what period you include in your treaty or in your contract. And in that period, typically speaking, you have a requirement to negotiate or mediate. In other words, you have a desire for the parties to cool off, hold back, and try to resolve the dispute amicably. In other words, not through litigation, such as arbitration, but through amicable means of this alternative dispute resolution.
Thank you, Mr. Dautaj. As we were discussing yesterday, arbitration is one of the most traditional sought after dispute resolution. But however, there are also other alternative modes of dispute resolutions. Could you please elucidate about the other modes that are available to resolve investment disputes?
Yes, so you have first and foremost litigation in courts, right? And some courts are really highly qualified. For example, if you litigate in the Supreme Court of India, you'll know you have high quality. The same goes for US courts, the same goes for Swedish courts, the same goes for English courts. So court litigation is an alternative. I'm not saying that is the preferred alternative if you're an investor from one country and you have to litigate in the home turf of another state. Mediation, as we have discussed, is an alternative. Conciliation is an alternative. Negotiation, which can be either on the party's own, it can be facilitated, and in best case scenario, a negotiation can culminate in settlement. You have something else that is called early neutral evaluation, which can be led by a trusted third party. And you have something which I am very interested in right now, and I think that this has grown in appetite, and that is fact-finding. So you can retain a body to clear out the facts. And when you have agreed to, or when you have finally settled what actually happened, what are the facts and circumstances, you will be more likely to push the parties to a settlement.
Thank you, Mr. Dautaj. My next question is pertaining to the other modes of dispute resolutions. Are there any significant conventions or the rules that the investors or the states have been using in the dispute resolution mechanism?
So I would say one, and I wouldn't say been using because it's pretty new, but will be using, and will probably be a good alternative to investment treaty arbitration. And that is the Singapore Convention on Mediation that was entered into force on the 12th of September 2020. So that is the short answer. And I think that that is the only, as of today, really serious or viable alternative. So I don't want to speculate on any additional other rules that could be, I mean, apart from fact finding would be really good at the permanent court of arbitration perhaps. But this is the big contender to investment treaty arbitration, I would say.
Thank you, Mr. Dautaj. As we were discussing over our last couple of days during this webinar session, we discussed that treaty planning is also very vital when it comes to investment disputes. So according to you, what must the parties do at the time of signing the treaty to use the other modes of dispute resolutions that is available?
So this question is, I would say, what could parties do? So the parties that negotiate a treaty is not the party that initiates the arbitration. So the arbitration is triggered by a unilateral standing offer to arbitrate. So this arbitration clause or any other clause of dispute resolution is entered into by two or more states, depending on if it's a multilateral investment treaty or bilateral or any other type of international investment agreement. What can the parties do? The parties can do whatever they want to do. So the parties can agree to mediation, they can agree to court litigation. It's up to the parties, as India and Brazil did here. They put in a dispute resolution clause that was fundamentally different from other types of arbitration clauses. Brazil, in some of their more recent bilateral investment treaties with, for example, African states, they've removed ISDS altogether. They have no reference to arbitration. So what can the parties do? And the parties in this question is not the investor and the state, but the party in your question here, the parties are states, both are states that agree to a dispute resolution clause that then can be triggered by an investor. What can the parties do in terms of being, so if you would be an investor from, say, Suriname in Africa, from Suriname, and you would invest in Brazil, and your bilateral investment treaty does not offer arbitration as the venue for dispute resolution, you can include in your contract with the state an arbitration clause. So if you are the party from that standpoint, in other words, the party making the investment, not being covered or not having a bilateral investment treaty that protects you, you can try to protect yourself in the manner you want to be protected through contract.
Thank you, Mr. Dautaj. Mr. Dautaj, my next question to you is regarding multi-tier dispute resolution. So could you please elucidate about the dispute resolution and how has it worked in reference to any case? Or will this introduction of a multi-dispute resolution will prevent or mitigate disputes in a better manner?
So if you can specify here what you mean, do you mean, so the question is, are we talking about a mechanism prior to the arbitration, such as going to mediation, or as you said, not in the question, but subsequently, you're talking about several parties being joined, in other words, consolidated to a matter. So if
I'm talking about the first one, like going to negotiation, then if that doesn't work out, then mediation, and then finally landing up to arbitration.
Okay, so this ties to your question on the cooling off period that we had discussed and the amicable settlement procedure. And the actual question that you're asking, in other words, is how effective is it? This is your question. How effective is it? And it depends on very much. It's not all that effective as it could be, unless the state is really working hard to settle the dispute. So some states have more of a reputation to quickly settle disputes, and some has a legal culture where mediation, for example, Japan has a legal culture where mediation has a much broader space in their dispute resolution framework. Other legal cultures are litigating more frequently and more often. That's a part of their manner of solving disputes, and there are no hard feelings in that litigation. Merely, these cultures are using litigation as a means to an end. In other words, understanding, okay, we have a disagreement here. How should the contract be interpreted? Who should be compensated for what? An arbitrator can find out. And that is American culture. Even Indian culture is also solving disputes through litigation. So I think that the effectiveness of mediation and negotiation pre-arbitration depends very much on the state, I would say, more probably than the investor.
Mr. Dautaj, my next question is, why is it important to consider any other alternative dispute resolution than arbitration? Will it be effective?
So I am a big proponent, as you know, of investment treaty arbitration. But I am also a big proponent of mediation, if it's possible, where it is possible. I'm also a big proponent of prevention and mitigation, where it is possible. I'm also a big fan of conciliation, of negotiation, of fact-finding, where it is possible. So as I have said, these 2 days, our jobs or our job as a dispute lawyer is to quickly reach a solution, a good solution for your client, for all parties involved. And if that happens before arbitration, in other words, investment treaty arbitration, even the better. Anything that actually works long-term, a long-term solution, and have positive side effects. In other words, when I talk about side effects, I talk about what can also stimulate investments in the host state. In other words, attract, promote, facilitate FDI. All such mechanisms are to be praised. And as I said earlier, and as Professor Dr. Kaj Beer has said in his excellent book on investment treaty arbitration, at the end of the day, the proof is in the pudding. So I am not a bigger fan or a lesser fan of any dispute resolution mechanism or procedure in and of itself. I am a fan of everything or anything that actually works. And my firm, or I would say my firmly entrenched belief, is that investment treaty arbitration has been by far the best alternative to settling investment disputes. With that, and before we take a Q&A, I want to thank you all very, very much for 2 exciting days. It was my great honor and privilege to meet with respected arbitrator and Professor Inbavijayan and with Ms. Sameena and her entire team. So I want to thank you very, very much.
Thank you, Mr. Dautaj. To me, the last 2 days has been really thought-provoking and intriguing, as I wish to pursue investment treaty arbitration under you in the near future. So right now, I think there are a few questions that are popping in, so I will moderate them one by one to you. So the first question is from Krishnamurthy. He asked that, do you recommend that a failure of mediation can the same mediator act as an arbitrator? After all, he is a human being and certain fundamental information received during the mediation cannot be erased from his mind.
Yeah, so this is a very topical debate. This has been debated to great extent. There are different opinions of this, and I would be inclined to say no to this, but I'm also not exclusive in my answer. If someone can make a very compelling argument for otherwise, I would be happy to hear them out. I can say this: I have read quite a few articles on this topic, but I have not made up a firm opinion on this. And I would also say that as I am still young and I have not served neither as a mediator or neither as an arbitrator, but I have been a counsel and a professor, I would give this answer a few years in the making and in the building, and I will come back to you when I have gray hair. So I will wait until I actually have that expertise.
Thank you, Mr. Dautaj. The next question is from Ms. Sharon Elizabeth. She's posting that, would the EU's proposal of judicializing the investment treaty arbitration be a step in the right direction to curtail the inherent investor bias of the investment dispute resolution in terms of avoiding multiple bites at the cherry?
Okay, so I mean, it's questions that are framed in that manner are interesting, because I mean, you are making a presumption in the question that maybe it doesn't necessarily have to be there. I think that no, I am not, as I said earlier, I am very much against EU's proposal. I think that the judicialization of investment treaty arbitration undercuts all the fundamental elements of arbitration. And as I said, the proof is in the pudding. International arbitration has worked. It has been a great success, both commercially and treaty-wise. It can definitely be reformed and improved, such as enhancing transparency, such as taking account investor obligations, as we discussed, such as including in applicable law environmental law, international environmental law, international human rights law, labor protection and standards, including, for example, also as India has done, corporate social responsibility is not a bad idea. But to fundamentally reform the investment treaty arbitration process into something such as a permanent body with elected judges from the EU and from, for example, US or Canada or Vietnam is, according to me, not the right path forward. Quite the opposite. I think it's a regressive step backwards, and time will tell and time will prove. And if this materializes into reality, it will be affecting small and medium enterprises, as big enterprises will most definitely include arbitration clauses in their contracts, individually negotiated with states.
Thank you, Mr. Dautaj. We are taking one last question before I hand over the floor. This is from Mari Sport, if I'm pronouncing your name right. Does investment dispute mediation is a community mediation, especially we have to accommodate non-state actors?
Can you repeat that question, because it sounded like a statement? So repeat that.
Does investment dispute mediation is a community mediation, especially when we have to accommodate non-state actors?
Okay, so it started off as a question. It didn't end with a question mark, and then it went into a statement. So if it is your statement, fine. I mean, and should mediation include third parties? I don't know how effective mediation would be, because the more alternative viewpoints you have, the less likely it is that you can settle something through consensus. It is the more likely that it will end up in litigation and finally determined by an arbitrator. If that is the statement, I can't really tell what the actual statement was. So please feel free to come back with a clarification if you want. But if I understood it correct, that is my view. I wouldn't say answer, because I don't possess answers. I possess views.
Thank you, Mr. Dautaj. Mr. Dautaj, thank you so much for your time and efforts in coming to KFCRI and imparting your knowledge in the realms of investment treaty dispute. And right now, I would like to hand over the floor to Mr. Inbavijayan for his concluding remarks.
Thank you. Thank you, Mr. Yilli Dautaj. It was really an enlightening sessions for both days, and we learned a lot. Very interestingly, the information what you happened to share about this India-Brazil bilateral investment treaty, it is really an eye-opener. And I think many practitioners, legal practitioners in India would opt to choose this particular sector, that is the investment, which is having a great opportunity as practitioners, as advisors, as well as experts, whether they are going to take up in an in-house role or an external counsel. Further, what is the takeaway from the last 2 days about this investor-state mechanism? The good part is India is not signatory to ICSID. We are yet to sign it, but anyway, we are part of the MIGA, that is Multilateral Investment Guarantee Agencies. We are expecting to how we are going to adventure with the existing BITs, and whether we in future get into the ICSID platform, wherein there is going to be a mandatory final outcome, an arbitration conducted by the World Bank Arbitral Tribunal. These all are very hybrid to most of the practitioners right now. But we can wait and see how far it is going to be seriously considered in the curriculum, the law school curriculum, as well as in the practice when it comes to the national courts getting involved in all these investment disputes. With these few words, I on behalf of Kovise Foundation, Conflict Resolution International, wholeheartedly thank Mr. Dautaj for spending a valuable time. That's most important, the valuable professional time you have spent with us sharing about this investor-state arbitration. And this would be a beginning. We hope that your support for KFCRI in all its activities, especially on the investor state line, would be the future. I hope so. And I thank you on behalf of the entire team. I thank Sameena Syed for effectively moderating, with making an echo of Mr. Dautaj. I think more than 50 times I could count it. And it's really wonderful, making all her clarifications done with Mr. Dautaj on the investor state arbitration. And I thank other team members, Mr. Shanmo Dev, who moderated yesterday, Mr. Swethan, who moderated today, and the other managing committee member, Mr. Shahrukh Kumar. All these members have reasonably spent to learn about this investor state dispute. That is very important. And not only learning on behalf of KFCRI, it has also been conveyed to our members, whether the associates, affiliates, or the fellows, and also well-wishers of this organization. And with these few words, I hand it over to Swethan.
Thank you very much, sir. Really appreciate it.
Thank you, sir. Thank you, Mr.Yilli Dautaj, and thank you, Ms. Sameena. So before we end the session, a bit of logistics for the next events of KFCRI. So in this week's end, we have our first associate at mediation practice, the accreditation course for the associate level at KFCRI. People who are interested can visit our website at www.kfcri.org or reach us at kfcri.adr@gmail.com. We have, so this is the second session in the KFCRI sector specific webinar series. So our first session was in domain name disputes, and the second was in investment arbitration. And we plan to take ahead this project and go into various sectors related to arbitration or ADR. So if you would like to follow us on this particular webinar series or any other events of KFCRI, please subscribe to our YouTube channel or our social media pages in Instagram, Facebook, and LinkedIn. Thank you so much, your panelists, and of course the entire KFCRI team of interns and associates who've been working behind the curtains for this one. See you all soon. Thank you.
Thank you so much.
Thank you, Mr. Dautaj.
Thank you, Mr. Dautaj.
Thank you very much. It was my pleasure. Thank you very much. Thank you.